Morning, Your Honors. May it please the Court, my name is Joe Desmond, and I represent the Malden Dexter house. We are here on the, to argue my allotted time, the argument that was addressed by my brother earlier about whether or not a healthcare agent has authority to execute a binding arbitration agreement.
Well, don't you, before you get there, though, don't you have a problem with the fact that the person wasn't actually, hadn't been named, or it hadn't been activated at the time that the agreement was signed?
I disagree with that, and I think the trial court made an error both in fact and in law, in that what the trial court said was that because the attending physician who made the determination that the woman was demented didn't specifically intend to activate the healthcare proxy, that therefore it failed, which is not the law. The healthcare proxy statute says that when a physician makes a determination that a resident is incapacitated, the healthcare proxy is triggered. The physician doesn't have to have a subjective intent.
Is there some, I thought there was some consultation that had to happen of the physician
There was,
with a...
Correct. And in this case, this woman came to this nursing home following a geriatric psychiatry inpatient hospitalization where she was evaluated by a team of psychiatrists who diagnosed her with being demented. In the hospital, and this is clear on the record and not disputed, I don't think, in the trial court, that the attending...
Okay, I don't want to take all your time. I understand your point, yes.
And so the point is that the activation springs from the determination of the physician, whether or not he is aware, in fact, if there's a healthcare proxy. Setting aside the factual issues, the larger picture that was raised by my brother is whether or not that healthcare agent has the authority to execute, in this case specifically, an arbitration agreement. And I would submit that the Tennessee Supreme Court got it right in the Owens versus National Healthcare case, which decided that a healthcare agent does have the authority to execute a healthcare proxy.
Does Tennessee have the same statute that we do?
It is
with the same sort of legislative history?
It's very similar in the terms. In Tennessee, they call it a durable power of attorney for healthcare, and the statute says that the durable power of attorney for healthcare is empowered to make healthcare decisions. And so, to that extent, it's
Does
quite
it define healthcare decisions in the statute?
It does.
Similar to ours?
Very similar to ours. The one biggest distinction I would raise between the Tennessee healthcare proxy statute and the Massachusetts healthcare proxy statute is that the Massachusetts healthcare proxy statute specifically goes on, and we heard about the legislative history from my brother. Our statute says that the decision of a healthcare proxy shall take precedent over all others, including a durable power of attorney. And that's in the text of our statute that is not in the Tennessee statute.
Could you say that again?
Sure. The healthcare proxy, section 5 of the Massachusetts healthcare proxy statute, says that the decision of a duly appointed healthcare agent shall take precedent over the decision of all others with respect to those healthcare decisions, including, specifically in the text of the statute, including a person acting pursuant to a durable power of attorney.
But that just begs the question whether it's a healthcare decision or not. I mean...
I disagree, Your Honor.
Why does that help you?
Because what the healthcare proxy statute says and what it grants to every individual the right to make healthcare decisions. It's an intangible right. It doesn't give the healthcare proxy the right to execute any contracts.
I understand that.
The question is, as Justice Gantz raised, is whether or not the healthcare proxy has the tools to implement the decision. That is, how do we allow a healthcare agent to make healthcare decisions without granting the authority to implement those decisions? When you go into a nursing home, the decision that is granted is, okay, we're going to admit my mom or my dad to a nursing home. But that, in and of itself, has practical consequences that the Tennessee Supreme Court got right. And the Tennessee Supreme Court recognized that there are contracts that have to be signed in order to effectuate the healthcare decision. And the Owens versus National Healthcare decision correctly points out that any contract, even the admission contract, even if that is a healthcare decision, that is the healthcare decision, we can agree, and I think Cohen versus Bolduc, this court said the healthcare agent has the authority to admit someone to even a psychiatric facility. When there's an admission contract, that in and of itself, the contract is a legal decision. That's not a healthcare decision. The healthcare decision is the intangible decision about I'm deciding to put someone in a nursing home or in a psychiatric facility. But it has,
And to pay for it.
and to pay for it,
And
certainly.
to pay for it, you may need to sell the person's house. And so the healthcare proxy gives you the authority to enter into a purchase and sale agreement to sell that person's house in order to implement the decision to put somebody in a nursing home?
I didn't say that. I think,
I'm just saying, how far is the scope of this authority?
well, I think it has to be, Your Honor, and the basic principle under the healthcare proxy statute is that the healthcare agent has to have the authority to implement a healthcare decision.
So,
And to that extent, that when the admission agreement, and in this case, the arbitration agreement is part of the admissions agreement. It was optional, and it became part of the admissions agreement. Just like whether or not they were going to do the housekeeping, whether or not they were going to do the resident's laundry, things that are not healthcare decisions. You cannot call a healthcare decision whether or not the family is going to do the laundry or whether the nursing home is going to do the laundry. It just is not a healthcare decision. To rule that the healthcare,
Such a decision doesn't really waive a very important right.
well, it does.
That's
It
within the
does, because we
balances.
can't distinguish between, does the healthcare agent have any right to enter contracts, or does the healthcare agent not have that right? And I would suggest, Your Honor, that no state can make a law that says that the healthcare agent has the right to enter into an agreement to have the family do the laundry and then not respect the right to arbitrate those same claims, that is, the healthcare claims at issue. And by the same token, in this case, and by the way, the plaintiff in this case has brought a breach of contract action, seeking to invalidate a portion of the contract, but not other portions of the contract.
Mr. Desmond, your time is up.
Thank you, Your Honor.
Thank you.
Good morning, Your Honors. May it please the Court, my name is Michael Resendes, and I'm here on behalf of the appellee, Mr. Licata. As Judge Botsford just appropriately pointed out, the threshold issue on this particular case does contain issues of fact as well as issues of law, and that is whether or not, at the time, Mr. Licata signed the arbitration agreement, whether he was even a healthcare proxy. And we submit that certainly the trial court ruled correctly in that he did not.
But why would that matter if he essentially adopted it by not rescinding it when he did get the healthcare proxy?
Well, he would not have the authority in any event because he is the agent and not the principal. And any authority, the only person that was a purported party to the arbitration agreement was his mother, Mrs. Licata. And so if there were to be any issue of adoption or ratification subsequently, it would have to come from the principal, not from the agent. The agent cannot pull himself up by his own bootstraps and say, I'm going to come afterwards and ratify or
But then you're getting to the main argument, that is that this decision isn't a healthcare decision
That's correct.
under the statute.
That's correct. And our statute is very clear on that. And as was pointed out by my brother earlier, at the time that the statute was enacted, there was extensive consideration by the legislator on behalf of the citizens of the Commonwealth as to just how far the statute would go. And there were several bills that were in front of the legislature at the time. And one of the bills was Bill 3367, which requested that the durable power of attorney statute be intertwined with that of the healthcare proxy statute, and that was declined. So it was considered, it was volitionally declined. There are two separate and complete different things, and each person has his own right, to make his own choice as to who and when he is going to place the control of his well-being into another person. And there are many considerations, obviously, that people would take into making such a serious decision. And if it is, if they are to place in the hands someone a durable power of attorney to make decisions that are legal decisions, they may look to, or they would look to, a person who would be qualified, have some experience, some competency in that area. And the court considered that in the Miller versus Cohen case, in carefully considering what the qualifications of Mr. Miller's son was in entering into contracts.
So
On the
what-
other hand,
what
with
would
respect to the
be-
proxy,
What is your view as to the status of all those other agreements which go to payment? All those Medicare and Medicaid payments, would those be within the scope of the healthcare proxy? They don't relate to health care, they relate to the payment for health care.
the direct, they're not contracts. If there are documents that are signed by the proxy with respect to Medicare and Medicaid, they are not contracts that he is entering into on behalf of the patient for direct payment, not from himself, not from the patient, nor from Medicare or Medicaid. Rather, they are authorizations.
So, well, their authorizations, are they not effective because the person was not authorized to do it?
Well, the authorization that is granted by the patient with execution of a healthcare proxy is for healthcare decisions that would relate directly to decisions that involve the provision of treatment. It is clear on the record in this case that the arbitration agreement was not something that was contingent upon the provision of treatment. It was not something that in any way dictated or regulated the extent or type of treatment that would be given. It was not a healthcare treatment decision.
But I guess here's my concern, and you can address it directly. We are not permitted under the FAA to treat arbitration agreements any differently, and certainly no worse than other types of agreements. And therefore, it seems that we should treat arbitration agreements the same as other agreements that are in terms of the same view as to what constitutes a healthcare agreement. If we define it very narrowly, as you seek to, I think, are asking us to, then all these other financial issues arguably are outside the scope of the healthcare proxy, and that means that you can't get admitted to a nursing home unless you go to probate and family court and get a conservatorship. I mean, there's a practical problem here about an Alzheimer's patient trying to get into a nursing home, and the nursing home saying, we can't take you because you're not authorized to sign these forms because you have a healthcare proxy but no durable power of attorney. So go away, go to court, and come back with one. I mean, that's my concern.
The specific events that the court is asking about are not contracts. The patient does not enter into a contract with the federal government under Medicaid or Medicaid, or Medicare or Medicaid or the state government to provide payment for health care treatment. It is not a contract. It is, in effect, an act that the proxy would take as part of the authorization to provide the treatment to the patient. It is different than a legal contract, such as Judge Link suggested, where, well, does he have the contract to go, the authorization to go out and contract to sell a house or to buy a car or to invest in the nursing home? No. The healthcare proxy does not give him that authority. He cannot choose, well, I'm going to invest this principal's money into this nursing home. No. But with respect to the execution of an authorization form with Medicare or Medicaid for the payment directly of the treatment that's being provided, that is, again, not a legal decision. That's something that we are entitled to by fact of our citizenship or our place in the citizenship, whether it's within the Commonwealth or whether it's federally. We have certain benefits that we get, whether it's Social Security or Medicare or Medicaid. They are not by contract.
Counsel, your time is up.
Thank you, Your Honor.
Thank you.